Morning, Mr. Olabi.
Good morning, Honorable Tribunal. Good morning, sir.
Is the SN available?
No, she's not with us.
Okay. We want to confirm so that we don't.
Brief protocol.
As the tribunal pleases, we must observe.
Let's take the number one. It's for adoption. Then we'll come to your hearing.
Number one on the call slip with appeal number T8/SSG/013/2025. That is the Bayelsa State Board of Internal Revenue Records, the initiate PLC.
This is your adoption. Just adoption of the written address. See, my auditor is not the position. My colleague says that she doesn't have instruction to process examine, so I only adopt for them. So at the end, they will come back. I don't work. Written the position. No. No, position of defense. For position of defense. Yes. Yes. No, that is not the process. It's an adoption of the written deposition of who is the position? EW2 at the second person. This is a continuation of defense. The last step.
But is it just that adoption we don't want to do?
Well, we would have been ready. Yes, sir. The last time you said we are people that are going to allow us to take the second witness on the next state. Yes. And so we are just not a continuation of defense. But Sabian is not here. If you recall, he said he may not be here. So the colleague he sent has said that she's not instructed to cross-examine. So we only adopt our witness will only adopt her position. So let's see. It means you kill the witness when it comes to cross-examination, then you take a base. Yes, that's what I was making the tribunal about. When you say adoption, actually. Okay, I'm sorry. I thought, okay, it sounded like adoption of written address. Sorry about that.
They are still miles away.
You made us. Oh, I'm sorry. I'm sorry about that. The other lawyers. Sorry about that. Call the witness. Okay, wait. You made us look as if it was for adoption of written address. I'm sorry. Sorry. Yes.
May it please the Honorable Tribunal, I am V. Kokoja. I humbly appear for the appellant.
Yes. I am Sylvester Adaka. The chairman, I appear with lawyer Zawi Abbas. So chairman with permission of the tribunal. Together we are here.
The video is off. I'm not here.
Yeah. Yes. And people. Respondent,
No, Mr. Chairman.
Who for reference?
Olaide Odejobi, sir.
Ola,
Olaide
Odejobi.
Odejobi,
Is this one?
company secretary, sir.
Everyone that said there is no legal advisor attached to the pen.
Yes, sir.
Okay.
Same.
Let me see which thing. There is. Yeah, so. Yes. Your condition, my colleague will conduct.
One. You're about to be administrator for Can you talk your right hand and say your full name after me? Your full name, please.
I, Olaide Odejobi,
Hereby affirm
do hereby affirm
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the
the
truth,
whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
You have pen? Yes. Sure.
Please, for the records, can you tell the court, the honorable tribunal, your name, your full names? Yes. Sir. Advance. Please, for the records, please, can you tell this honorable tribunal your full name?
My full name is Olaide Christiana Odejobi.
Where do you live?
I live at plot 4, Road 4, Diamond Estate, Port Harcourt, Rivers State.
Who else? So you give us a.
Plot 4, Road 4, Diamond Estate, Port Harcourt, Rivers State.
Diamond is the word.
Port Harcourt, Rivers State.
This address, the one you put in your. Is that the official address?
Yes, Mr. Chairman.
Plus 400.
Plot 400. Location New Road, that's the official address.
Okay. Okay, good.
Now, for the record, what do you do? What work do you do?
I am the company secretary of the Initiate PLC.
Yes.
Now, recall that on the 13th of October 2025, 13th of October 2025, you filed a witness statement of oath in this matter. 13th October 2025. recall that on the 20, you said that is correct, sir.
Yes.
Yes. You also recall that on the 28th of November, 28th November, you filed 28th November 2025. You filed an additional witness statement on oath in this matter. That is correct, sir. Please take a look at this. Documents that they're going to show you now. And to confirm that these are your witness statements. And this one.
I confirm that the documents,
They are your witness statements.
they are my witness statements.
You want to adopt those two statements as your evidence. You want to adopt them as your statements, as your evidence in chief in
Yes,
this
yes, yes, I need to adopt that as evidence.
In your witness statements that you just adopted, you refer to some documents. Take a look at these documents. They are already in exhibits as exhibit GW1A to GW1O. Just kindly look at those documents. Are those the documents you referred to?
Says we what?
DW1A to DW1O, already admitted.
Yes, I confirm that they are the documents.
Perform the work.
You confirm that those are the documents to refer to in your witness
The
statement.
witness.
That's what I'm asking her. Do you confirm?
I confirm that these are the documents.
How many documents?
One of them.
How many?
DW1O.
I'm gonna bet that.
They're actually 15.
I'm gonna work that.
15.
Work. Okay. Yeah. You yes.
the elevator to be pregnant.
I call for that reason.
I'm regulator.
As a tribunal.
Yes, I'm going to decide Yeah.
Honorable chairman and members of the tribunal, that will be all the chief for this witness. To hand over to our colleague. We're very grateful.
Chairman, subject to the compliance of the honorable tribunal, will be humbly requesting for date for cross-examination of the witness.
Complete in August. Yes, the one for 10, yes. Use my phone. You said, okay, 1 week, 10, that's, August,
Yes, Mr. Chairman.
It's coming in, Mr. Chairman.
okay.
We're very grateful.
But you already get over this.
No, okay, that's.
My consent of both parties, this case is adjourned the 10th August 2026 for presentation of this resolution.
Request.
You can start them.
Thank you. We're very grateful.
So, what's this? Do the one.
Yes, sir.
Not at all. What is it? Oh, one thing. Four, number three. What number three? Go there, I number two. Yeah,
No, sir.
yeah.
No, sir.
Okay, Richard. Go number three.
Number 3 on the topic is a virtual with appeal number TAT /SFS 024/2023. That is Chevron Nigeria Limited versus Delta State Internal Revenue Service.
Yeah, come on, go ahead.
Sir.
Yeah, we're not seeing it for a long time. You want to stay with us?
You stay.
You
Chairman,
go.
this-
So our assignment to the UR matter. That's what it is. You have other matters to think of.
No, sir.
Only this.
Yes.
Appearances.
With profound respect to the Honorable Tribunal, Afolabi Elebiju. Afolabi Elebiju appears for the appellant, and appearing with me are my learned friends, Ayoleke Owolabi and Abdul Salam Salam.
Yes, respondents.
If it pleases this honorable tribunal, my initials are AO. AO are my initials. Gegbada. Gegbada is my surname. It is spelled as DJE GBA DA.
You're leading your wife.
Yes, my wife and one other. ID Gegbada. ID Gegbada as my learned wife, and EN
ID.
Boniface. ID.
Sorry.
one. ID Gegbada. Identity card ID Gegbada. And EN Extended Nigeria, EN Boniface appears with me for the respondent. The representative of the respondent is also here with us.
Yes, party representatives, appellants.
Appellant is represented by Mrs. Uloma Okpechi. Mrs. Uloma Okpechi, the deponent to the witness statement.
Sorry. Is it Uloma or Uzoma?
Uloma, ULOMA, L as in London. She's the team lead payroll unit of the appellant.
Uloma what?
Uloma Okpechi, OK, O as in orange, K as in kingdom, P as in Paul, E as in England, C as in club, H as in house, and I as in India. Okpechi.
Designation.
She's the team lead payroll unit of the appellant.
Designation.
Yeah, she's team lead. Team lead, payroll unit, finance department of the appellant.
Yes, respondent.
Yes,
Representative, respondents, any?
So yeah, it is.
Apologies, sir.
The respondent.
Representative, any
For the respondent.
who is representing the respondent?
Maybe network issue now. Because said they have their. Was first comment. It is a network.
Mr. Jekbada. It's off.
Adeyeri, Adeyeri.
Can you come again, please?
Okay, if Ifemena Adeyeri, Ifemena is spelled as EFEMENA. Ifemena Adeyeri. Ifemena EFEMENA. Ifemena.
Yes. Yes.
Adeyeri. ADEYERI.
Designation.
Adeyeri.
Designation.
She's the assistant director, State Council, assistant director. Assistant Director, State Council. We're grateful, sir.
Good, Mr. Elebeju.
Yes, we provide respect to the tribunal. This matter was adjourned for commencement of trial today. And although we had initially planned to be in Benin physically, considering that our learned friend is also appearing virtually, on second thoughts, we felt it would be better to also appear virtually. And in that regard, we made an application to the tribunal, and with the tribunal's indulgence, for which we are much obliged, we are happy to appear virtually today.
Yes.
So our appeal, the background to the today's hearing is that we have a notice of appeal, which is dated the 26th day of May 2023. The appellant filed a notice of appeal dated 26th of May 2023. It's an 18-page document, and it had 11 grounds of appeal. In the notice of appeal, the appellant is seeking 15 reliefs, and this relief has evolved, and we're going to make a few preliminary comments before trial will actually start. So we're seeking 15 reliefs, which has evolved, and essentially we are challenging a demand notice, cum nora, which is issued by the respondent, which is dated 2nd of May 2023 for 41.9 billion and 55.8 billion, which represent their additional assessment for.
Okay.
I'm sorry.
Go on.
All right.
Go on.
So the appeal is against the demand notice issued by the respondent dated the 2nd of May 2023 for two amounts representing two periods. For years of assessment of 2006 to 2010, the amount is 41.9 billion. Then for 2011 to 2018, the amount is 55.8 billion. The appellant is essentially asking that the demand notice be set aside for the many grounds that were set out in the notice of appeal. And There were related two demand notices before then, but they still cover the same figures. These two demand notices were dated 24th of January 2023. And what has happened is that the demand notice of 2nd of May has mutated. So our appeal is that that demand notice and every other thing founded on it, every fruit of that tree, be set aside for being invalid, ultra-virus, being issued outside of due process, and so on and so forth. And in this regard, the appellant filed 2 witness statements. The appellant filed 2 witness statements in support of the notice of appeal. These 2 witness statements are dated 4th of December 2025 and 21st of May 2026, respectively. The respondents have also filed a responsive process. The first one was dated 28th of October 2025, and their further process is dated the 12th of June 2026.
Yes, sure.
Okay. We have some preliminary remarks to make. Like we said, with respect to the tribunal, we are appealing against the demand notice dated 2nd of May and every other thing that has given, that it has produced, let me put it like that, every fruit of that tree. So what has happened, particularly with respect to 2016, to 2011 to 2018, is that the amount represented in that demand notice has mutated. It mutated from 55 billion to 203 billion, and finally to 25 billion. So our case, in respect of that second leg of the appeal, has evolved into challenging the assessment for 25 billion. And in this regard, following our application to apply for virtual hearing, which the tribunal has indulged us, we have uploaded all our exhibits to the witness. We've uploaded the witness statements and all the exhibits to the witness statements. The total number of our exhibits are more like 37 broadly, and we are ready to proceed. But we felt we should make this initial comment because our learned colleague, the respondent, has argued that the engagement that has led to the current situation should not be something that the tribunal should countenance. But we believe that pursuant to the statutory powers of the tribunal, particularly in the civil procedural rules, where the tribunal is empowered to engage in pre-trial conference and encourage settlement and all of that, what should be before the tribunal now is the current amount in dispute. The original amount in dispute, things have been narrowed down, issues have been narrowed down, and it's no longer the original amount. In fact, the amount has changed twice with respect to 2011 to 2018. We just wanted to make this comment so that the admission of evidence, everything can have a free flow. And if my learned colleague still feels strongly that the documents and even the position they took during the pendency of this appeal should not be before the tribunal, that can be an issue for address. Alternatively, we can take that as a preliminary point now and argue it out. But we believe that if we had a dispute about 10 naira, and eventually, as a result of settlement conversations, reconciliation meetings, engagements, and so many other initiatives, the amount is now 5 naira. We believe that it will be a waste of the tribunal's time to be looking at a dispute that is no longer current, to be looking at a dispute of 10 naira rather than 5 naira. We also believe that it will not be doing appropriate credit to all the efforts and the energies that the parties have put into narrowing down the issues. And that at the end of the day, if an assessment was issued in respect of an investigation exercise, and another assessment was issued under the same heading, pursuant to the same exercise, the only reasonable conclusion is that the initial assessment has been superseded or displaced. In other words, the most current assessment is the dispute right now before the tribunal. And as a matter of, now this is wearing my hat as a minister in the Temple of Justice. We should also note that the dispute in respect of 2011 to 2018, the appellant has been hamstrung from actually being able to challenge it effectively because the respondent has failed, refused, or neglected to provide the computational basis for that revised assessment of 25.8 billion. So on this note, subject to the direction of the tribunal and to any comments that my learned friend wants to make, we are ready to proceed. Thank you very much.
Yes, Mr. Fuller, I was going to ask if you wanted a pre-trial conference. If you wanted a pre-trial conference, we would have had one.
Yes.
And then to narrow down the issues.
Because this was
So, yes.
Okay. With due respect to the tribunal, thank you very much, Honorable Chairman. That is, we're just making that point to show that issues have already been narrowed down through the settlement conversations.
That's what I'm saying.
Issues have already been narrowed down, but our learned friend or the respondent is trying to make us go back to the status before issues were narrowed down. And we are saying that is not helpful to the tribunal and to the fair determination of this matter.
That's where we are saying a pre-trial conference would have brought out the issues that have been narrowed down.
Yeah.
So that we know exactly what we are doing.
Okay, we are happy to engage in that. If the tribunal, we are happy to engage in the pre-trial conference, especially.
Let's hear Mr. Ajegbada.
If it pleases Honorable Tribunal, very briefly, I have some few responses to give with respect to what the learned counsel to the appellant has said so far.
Mr. Ajegbada.
My lord, sir.
Yes,
sir.
before you, because I'm not comfortable with all the background story that Mr. Afolabi has tried to give.
Yes,
what
sir.
I was saying to him is, if both of you were inclined to have a pre-trial conference, would have intimated the tribunal, would have had a pre-trial conference where the issues are narrowed down so that we know that we'll concentrate only on those issues. So now with the background given by Afolabi, where does that stand? Are we going to rule on that? We're not
First off,
to me, we're not moving forward. Because if we wanted we would have had a pre-trial conference in chambers and then narrow down the issues with the parties.
So we'll just go on.
Because
thank you, Honorable.
You are going to make your own brief summary also in response to what he has said. So what is the position of the brief summaries you are giving?
Okay, sir.
Is it evidence? Are we going to, evidence? Are we going to rule on it? We can't rule on it. So in essence, the point we look at it as we're just killing time.
We're just wasting time.
We're killing time.
You know, a pretrial conference would have been fun.
If you want a pretrial conference, from what I can get now, it means both of you are disagreeing. You disagree on whether you have agreed on certain issues or not. From what Mr. Afolabi said, he said issues have been narrowed down. The task component has changed. The final task component has changed. And that from your opposition, he thinks that you don't think so.
Very well, sir.
Yes. So
now, very quickly, if
we should have ironed those issues in a pretrial conference.
My lord, ordinarily, these are not issues. Why am I saying that, sir? Before this honorable tribunal is just one notice of appeal. Exactly. And on the face of the notice of appeal, what they are challenging is clear. They are challenging the assessment for the period 2006 to 2010 and 2011 to 2018. The other issue counsel to the appellant just raised with respect to a tax assessment of 26 billion naira and some other issues, these are issues that came out during negotiation and reconciliation. They cannot be said to be part of their notice of appeal. So with respect to the notice of appeal, my lord, sir, we are ready to proceed. The issues have been canvassed and the documents related to those said periods are before this honorable tribunal. There is no relief whatsoever. There's no relief whatsoever touching on the issues that came up during negotiation, particularly with respect to the assessment of 28 billion naira. Those are issues that came up during negotiation. There are no relief touching on them. So the notice of appeal is clear, and that is why we are before court. Appellant counsel to the appellant raising issues with respect to narrowing down issues during negotiation cannot be part of the notice of appeal. So my lord, sir, today we are willing to proceed with hearing. They should feed their witness. If there are objections to be made with respect to the document they sought to tender, we would make the objections, and one way or the other, the tribunal will rule. But with respect to those issues counsel raised, they are totally unnecessary. They are not before this honorable tribunal, even though they made reference to them in their supplemental statement on oath. But the notice of appeal is clear. What they are challenging is clear. The relief they want is clear. There's no relief touching on the assessment of 20-something billion naira. It's not before this honorable tribunal. I wonder why counsel to the appellant I keep saying that.
Mr. Afolabi.
Yeah, thank you. With respect to the honorable tribunal, I think my learned friend is not appreciating the issues with due respect to him. What has brought us here is a demand notice seeking to enforce collection of an assessment or assessment for
second May, yes, 2023.
Yes, exactly, sir. So second 2023 for two periods, and we are saying, in fact, part of the issues, if I may just say one or two things, part of the issues, because it is during the pendency of this matter, for example, that they began to substantiate the allegations of fraud. They never did before now. So how was the appellant going to respond? You will respond after me. You will respond after me.
I think counsel to the appellant is delving.
You will respond after me. Now, why don't you respond after me?
He has the floor.
Please let him land. Go on, Mr. Afolabi.
Okay. So what has happened? In fact, I've not mentioned at all. So what has happened is that from that notice of demand notice, issues have evolved. That is the truth. I do not know why my learned friend will want this tribunal to be sitting over an assessment that is extinguished, essentially. I do not, because under the rules of this tribunal, we narrowing down issues for speedy, expeditious trial and equitable just determination of tax disputes is part of the objectives of the tribunal.
Yes, but you cannot narrow down those issues without in the absence of the respondents, or without a contribution from the respondents.
Yeah, I believe we can narrow them down. Essentially, what we're saying for 2011 to 2018 is that what is before this tribunal is 25.8 billion, not 55 billion. That is what we're saying. And that point needs to be appreciated in order for the trial, because the tribunal must be determining on what is live. The tribunal cannot be determining a dispute that is not live. The dispute that is live is 25.8 billion. And I just made that observation that even as of today, the respondent has failed, refused, and neglected to provide the appellant with the computational basis of that very assessment. So we may do trial, but I wonder how even effective the trial will be, because the appellant could not even object effectively to that 25 billion naira assessment. Because when the appellant asked for, please send us your computational basis, they sent us a summary. We then said, this summary is not sufficient. Please do as you have always done. You tend to send us, because this demand notice that initially brought us to the tribunal, they sent the computational basis. So they then said, oh, it is based on the payroll that we gave them. But the payroll we gave you does not show we are liable based on our interpretation of the law. So show us how you treated the payroll that made us to be liable. And they said no. Eventually, after saying no, the third time they now said, oh, we actually sent it via CD. And we told them, KPMG, who are the tax consultant to the appellant, does not have these CDs. The appellant himself does not have these CDs. You did not. What you did, you sent a letter and you referred to a schedule, and that schedule was a one-page summary. That's what you sent. And we sent them all this information. Please send us the computational basis, and as of today, they have not.
Mr. Folabi.
Yes, sir.
And Mr. Jebata, please, can we have a pretrial conference?
At the tribunal basis, from our own viewpoint.
Huh?
It's okay. It's okay.
Jebata, are you supposed to, because that's, you have to come to the
Brief
tribunal.
remarks, please.
Huh?
I think I'm not opposed to having a pre-trial conference, but subject to the convenience of this honorable tribunal, I would like to make some brief comments. I feel they are very important, considering what counsel to the appellant has presented before this honorable tribunal, please.
Go on.
Okay, sir. Now, at the risk of sounding repetitive,
Just a minute, let's come.
the appellant filed a notice.
Mr. Jebata, just a minute. Want to confirm that the recognize is on. Okay, go on.
Thank you. The appellant filed a notice of appeal with respect to a demand notice dated 24th January 2023, and also another correspondence dated the 2nd of May 2023. They are challenging the assessments for the period 2006 to 2010 and 2011 to 2018 to the tune of 41 billion and 55 billion respectively. That is the notice of appeal before this honorable tribunal, to which we responded and they gave their final response. And also, sir, with respect to that, why this matter was still pending before this honorable tribunal, parties opt out to settle amicably.
Yes.
Different correspondences were made in a bid to foster amicable settlements, one of which was the assessment of 25 billion naira. It only came up during reconciliation. As a matter of fact, which I've said before, there's no relief before this honorable tribunal vis-a-vis the notice of appeal challenging that assessment of 25 billion naira. There is no amended notice of appeal also to introduce that 25 billion naira. More so, sir, it should not be justice to the respondents if counsel will open his hands, get information made during negotiation or reconciliation, only to use it during substantive hearing, because that is what counsel is doing on one hand. The secondly, again, counsel also proceeded, the counsel to the appellant also proceeded to make comments with respect to payrolls. Make comment with respect to the fact that the respondent did not give them the opportunity to do their defense respectfully. These are issues bordering on the substance of the case. And I do not think respectfully that they should be allowed to do that. We are before this honorable tribunal. With respect to the notice of appeal, they filed no amended notice of appeal. And the issues are clear. They are challenging the 41 billion and 55 billion. That is why we are here. The issue of 25 billion naira, pay slip and the rest, they are totally irrelevant. If they want to introduce it, better still, they should file amended notice of appeal to bring in the 25 billion naira. We'll meet them at that point. But as for now, they cannot be slowing us down because of what happened during negotiation. It is most unfair. The matter can proceed for hearing.
With due respect to the tribunal.
Mr. Afolabi.
Yes, sir.
What we here understand is that while this case was pending, there were negotiations. There were attempts to reconcile.
Correct, sir.
The tax component was narrowed down to 25 billion. To about 25 billion.
Yeah, the 25 billion, that is where they got to, and we haven't agreed.
Yes,
and
you haven't agreed.
We have asked.
You were part of that.
We're still challenging it.
You were part of that.
Yes, sir.
You were part of that meeting that brought the tax component to 25 billion.
I was aware. I've
Yes.
been aware. I didn't attend all. Yes, sir.
Yeah, it's you.
Whether you attended or not,
For the one representing them, is you.
your team members
You are the one
were privy.
Yes.
Your client was privy to the reconciliation.
Yes, sir. So
Yes. The point the matter is making, and we have seen it from this point, is that 25 billion did not form part of your notice of appeal.
okay, sir. Okay, if I may I respond?
So your notice of appeal as presently constituted does not relate to the 25 billion.
I concede. However,
So
this
don't you think you needed to have amended your notice of appeal?
part of the challenge is that, thank you very much, we're much obliged, and my learned friend, even though we are arguing, we also appreciate your view, and we're much obliged for the hint given by the tribunal. With due respect, what has happened is that they keep changing positions. This, where we are today, my learned friend is suggesting that we get to wherever we get to the hard way versus the easy way. We believe that getting there the easy way, to the extent that the correct determination of the appellant's tax liability is the ultimate outcome, that should be fine. So long as we get to the correct outcome. The correct outcome is that the appellant should be paying just the amount of tax it is obliged to pay. And if we had gone to trial, with due respect, sir, if we had gone to trial before now, maybe the issues would have narrowed down up to the point of 25, but we still continue the trial anyway, because that is where we are today. So, and what we are saying, sir, is that what brought us to court is because part of our relief also includes such further order. Such order and further orders as the tribunal is minded to make in the circumstances. So our reliefs are expansive. What brought us to court is the outcome of their tax investigation exercise for 2006 to 2010, and then 2011 to 2018. As of today, that assessment of 25 billion is the outcome of their tax investigation exercise for 2011 to 2018. That's the outcome as of today. It used to be 55. In fact, before now, with respect to the tribunal, before now, there was a time it was 3 billion. Before it became 55. But it was when it became 55 that we came. You know, and then before it became 203, before it became 25, I do not believe, because the tribunal, the utmost consideration for the tribunal is to do justice between the parties without adherence to technicalities and technical rules. So we do not believe, given the circumstances, that it is pragmatic for the tribunal to be deciding on a matter that is no longer live, or to be looking at the quantum of figures, because what it also means is that the respondent's efforts in getting to this point, the respondent is saying he wants to throw all those efforts away.
Okay,
I'm surprised.
Do you have any document evidencing the fact that the tax component was reduced to 25 billion?
Yes, I have it.
Yes.
In our list of exhibits.
Please. Come here. Please, can you hear me? You have it. Is it part of your notice of appeal?
Before the tribunal.
Yes, it is. Exhibit 32 and 26A. 26A is the one that talks about 203 billion. 26A.
26A where?
26A, exhibit 26A in the supplemental witness statement. The big one.
On 21st May.
Yes, sir.
Okay.
26A.
Okay.
And that's the letter dated 19th of May, 2025.
You don't need to go to let's see that.
Yes. This is the letter, sir.
What is 19th May?
You can follow me.
Yes, sir. And And the other one, with due respect to the tribunal, is Exhibit 32.
It's okay. It's
It's
okay.
the letter of 28th November 2025.
So we can go on with the hearing.
As the tribunal places.
So we have spent almost 1 hour. I call your witness if it's available.
As the tribunal places. So our witness is Mrs. Uloma Okwechi. And she's attending virtually.
Yeah, witness is Mrs. Yes.
Mrs. Uloma Okwechi, she's attending virtually. So I think the registrar will swear her.
Where is she?
She's attending.
Yeah, we can see her.
She's actually attending. She's
Yes, we need to see her.
Yes, we can tell.
Okay, okay.
Yes.
she has raised her palm.
Okay. Yeah,
Good morning, madam. If you can hear me, please after. Good morning. Hello.
Good morning. I hear you. Good morning.
Okay, you're about to be administered of oaths. Do you prefer the iron, the Quran, the Holy Bible, or words of affirmation? Please stand up, please. Can you please stand?
I'm standing.
Okay, like I said, you're about to be administered of oaths. Do you prefer the iron, the Quran, the Holy Bible, or words of affirmation?
The Holy Bible.
You have anyone beside you there?
No, I don't have. Okay, so words of affirmation.
So you are affirmed there.
Yes, I affirm.
So lift up your right hand and say after me. I, your full name, please.
I, Uloma Nkechi Okwechi,
Do hereby affirm
do hereby affirm
that the evidence I shall give
that the evidence I shall give
shall be the truth
shall be the truth
and nothing but the truth.
and nothing but the truth.
Please sit down comfortably and look towards this direction, the camera only.
Okay. Ms. Okwechi, you've been sworn on oath and you are now going to give your evidence. Please tell the tribunal your full name and your address.
My name is Uloma Okwechi, and my address is number 2 Chevron Drive, Lekki Peninsula, Lekki, Lagos.
Thank you very much. Please, can you tell the tribunal about your professional background and your relationship with the appellant?
I am a chartered accountant, a fellow of Institute of Chartered Accountants of Nigeria. I am the team lead of a payroll unit in the finance department of the appellant. I have the responsibility of overseeing payments of employee-related tax affairs of the appellant. I'm also, let me mention, I'm also a fellow of the Chartered Institute of Taxation of Nigeria.
Thank you very much.
And
okay, go on.
okay.
Go on, please. Go on. Please go ahead.
Yes,
just to talk about my relationship with the appellant, I joined the services of the appellant in April 2010, and I've been handling this the schedule of payroll activities since about 2 years now.
Thank you very much. So you are appearing as witness in this matter. Did you depose to any witness statements at all in this matter? Do you recall? Hello? I think I internet.
Yes,
I think our internet is hanging at the moment. We're more sorry.
Yes, from my side.
Hello? Okay. Okay,
Yes.
you are back. Yes.
Yes,
Do
I'm
you-
back.
Do you recall deposing to witness statements in this matter?
Yes, I swore to a witness statement on oath dated 4th December 2025, and also a supplemental witness statement dated 21st May 2026.
Thank you very much. I believe the tribunal, the registrar can help us to exhibit the first one. If you see them, the one of 4th of December 2025, will you be able to recognize it?
Yes, I will.
Okay, so it's going to be shown to you.
Okay.
number one. Ulama.
How's the second one? This is the second one.
This is the second one.
The first one, Ulama.
What's December 2025?
Yes.
Okay, can you please take a look at the screen? And maybe the registrar can help us scroll
To the signature page.
to help us scroll down to the signatures page. And then
Go to the last page.
can you identify that this is the witness statement you swore to?
Yes, I recognize it. It's my witness statement. I can see my signature there.
Okay, thank you very much. I see it's it's a witness statement of 6 pages as shown on the screen. Do you recall how many exhibits there are in that witness statement?
Yes, there are 5 exhibits.
Okay, thank you very much. So, what would you like the tribunal, to do with the witness statement today?
I want the Honorable Tribunal to adopt the witness statement of 4th December 2025 and the related exhibits as my evidence in this appeal.
Thank you very much. We'll be much obliged by the Honorable Tribunal's admittance of these documents into evidence using the extant numbering for the 5 exhibits. And for the ease of hearing, we send a list of exhibits. Actually, it's a 2-page list, which the registrar can also share on the screen. The list of exhibits, of the exhibits of the appellant.
Yeah, Mr. Adebana.
Yeah, with respect to the 5 exhibits annexed to the said witness statement or notes, that is the one deposed on the 4th of December 2025, the 5 documents, I am not objecting to any of them.
At the tribunal places. Okay. Mrs. Okwechi, you said you also deposed to another.
Just a minute.
Oh, apologies.
That's a minute.
Mr. Folabi.
Yes, at the tribunal places.
We don't have separate copies of this exhibits to mark them.
Pardon me, sir. Pardon me, sir.
I said we don't have the physical copies to mark. I said we detach them from your processes verified.
Yes, we have on the flash drive. Yes, the it's with the process. Each of the files.
They are attached. They are attached. What we are saying, we have to detach them from the process to mark them.
Yeah, I believe so. With due respect to the tribunal, if you go oblige us, sir. It's the same content in all the flash drives, and the council also has it.
You always have mistakes copies. Yeah. no, It's a question. And that question. There is a question. You should have thought.
Is this last content? Isn't it about?
Yes, that's a question. There's a question, but I'm thinking about it, so we can start this. You got this, you don't do this. They take out this from flushes and set. What I'm saying is not attached to my phone. This is. There is something. Maybe it's a what's December. Or maybe there is some. It's cellulose. Gives you presences. There's no which is going to piece it like something. She did it flushing. There's a flushing. So just there's no flash. It's fellow. Usually each document. That's it. Within the work, because the case maybe it's fellow. So it's the purpose of proper. Silence flushing. Yes. Probably just like that we should 1 to 4. This is. Yeah. Yeah. We should be. You have.
Yeah, follow up. Maybe from the.
Conversation.
Not in mind.
Yeah.
I wish I had this profile, I'm sure. But we don't have usually income, so I'm sure. Then. What's in the other says? From the owners. They're looking into. Your servants.
One of the questions. If fellow, so if you say what 5%, and then it's. So. Normal thoughts from the. Really effective ones. That is. You can look this up there. You know, or this is this up. Let's see what that is.
Let it go. Black doesn't fall. USB. And that last one, after thinking about it. Now, feel about it. So that is touched. Beside the flag is also a document.
Sorry, Mr. Folami,
Yes, sir.
we're trying to sort out here because the copy I have,
Yes, sir.
all your residences that you are attached.
No, sir. There are two documents, sir. The first one is the 4th of December document. Has only one flash drive.
I know, I say that your affidavit of 4th December 2023.
Yes, sir.
The documents you attach, my own copy, the 5 copy does not contain all of them.
Oh, okay.
Okay, sir. So you the exhibit 4. I'm so sorry about that. Maybe we can go through, sir, and just to go over what we have.
We are trying to resolve it. That's why it's taking time.
Don't worry.
Okay, sir. Okay, sir. Our apologies.
That's why it's taking time. We are trying to sort it out. Let's let us themselves have attachments.
Then with a large document of how the US in track is one. Maybe we know this is let it use in some and let it use in some but then later we will correct this one. Basis. We'll correct for it. I don't want it in the own. We didn't touch.
Yes, it's a lot of responsibility to touch. Yeah, so
So a lot of people, yes, need to start. Hospital plans.
the five documents annexed to witness statement of oath of the 4th December 2025 are admitted in evidence and marked respectively as follows. Letter from Delta State Internal Revenue Service dated 24th January 2023 with reference number DT/1 IRS/CNL/2006 to 2010/2023/1 as exhibit CNL. Letter from Delta State Internal Revenue Service dated 24th January 2023 with reference number DT/IRS/CNL/2011 to 2018/2023/1 as exhibit CNL2. Letter from KPMG dated 23rd February 2023 is marked as exhibit CNL3. The USB flash marked as exhibit CNL4. Letter from the Delta State Internal Revenue Service with reference number DT/BIRO/GROC/2018/002/987 dated 2nd May 2023 is marked as exhibit CNL 5 accordingly.
At the tribunal places, we're much obliged by the tribunal.
Sorry for the time. We have to be very careful.
We actually have to apologize that that mix-up brought some delay. And so we're much obliged by the tribunal. So in the course of the interregnum, we also consider the proceedings of today, and we want to humbly apply to the tribunal for an adjournment for continuation of hearing on the next date, on the basis that in order to really cut through the issues, we have decided, if the tribunal will oblige us, to amend the notice of appeal to include the two demand notices, and to frame our release in such a manner that in whatever shape or form that any assessment takes arising from that tax audit investigation exercise, whatever shape, our appeal, our release covers whatever shape, the fruit of the tree, whatever, whether it's orange, whether it's guava, whether it's mango, we want to cover all of them. So on this basis, we will most humbly be applying to the tribunal that we bring today's proceeding to a close to enable us amend our notice of appeal. And as a matter of fact, just our notice of appeal, we are amending, because all the witness statements, everything is still valid. The exhibits will still be valid. It is just the notice of appeal to include, just for the avoidance of doubt and to further help both ourselves, respondents counsel, and the tribunal. So we believe that because, like we were saying, we could do this the hard way or the easy way, and we're now with the greater respect to the tribunal applying that we adjourn to enable us amend the notice of appeal, and then we can now do it the tortuous way. Each of the exhibits, as my learned friend may have any objection, we'll be dealing with it on a one-by-one basis. So this is our humble request to the tribunal. We'll be relying on paragraph 5 of the objectives of the rules, which is paragraph 5A of the Tax Appeal Tribunal Rules 2021. Paragraph 5 says the objectives of the rules are to enable the tribunal deal justly, fairly, and expeditiously with appeals. And then this our suggestion, it helps the tribunal it helps with the narrowing down of issues, which other 17, Rule 2, and Order 12 also recognizes. Because if I may read, Order 12 enables a party at any time to amend this notice of appeal or any other process on such times as the tribunal may deem fit. So we're applying on the basis of Order 12 that we would like to amend our notice of appeal, and we would like to do so in furtherance of the need for the tribunal to deal justly, fairly, and expeditiously with this appeal. Because if we don't, actually, there may be a lot of cloggings. Things may be clogged. Right? And considering that we're not really touching the evidence we already have is what we already have. The only thing we're doing is just to amend the notice of appeal. We humbly move in terms of this application if the tribunal will be mandate to indulge us.
We just want to be clear on it. Mr. Afolabi?
Yes, sir.
This was adjourned for 2 days. So if you say let's adjourn to the next date, that is tomorrow.
No, we'll be vacating to those weeks.
We would be applying consequentially, sir, that tomorrow's date be also vacated, because in order to file the notice of appeal, we'll need a few days. We will be most humbly appealing to the tribunal to please indulge us by vacating tomorrow's date, so that we can properly amend the notice, have it served, and we're all ready to go on the next date. And on that date, we can, if our learned friend will not be opposing, which we don't expect him to do, we will just quickly move the motion, and once it's approved, once it's granted, we can then proceed to trial on that day, that same day.
Everybody respond.
Just a minute.
Okay, 1 minute.
I'm grateful, sirs. I'll be vehemently opposed to the application for adjournment. This matter was adjourned to today for the substantive hearing of the appeal. This is a matter that has been pending before this honorable tribunal for 3 years now. For 3 years.
Yeah.
Whereas the appellant has the right to amend his notice of appeal, they had all the time in the world to amend their notice of appeal. To amend their notice of appeal. On the last adjourned date, we're grateful.
Yeah.
On the last adjourned date, this issue as to the 25 billion naira assessment came up. Counsel to the appellant raised it, and I opposed.
Are you going back to that again?
No, sir, no, sir. I'm just laying a background as to why I'm opposing the application for adjournment, because he has given the court a reason for wanting the adjournment. They want to amend to bring in the 25 billion. So I need to respond to that to set a background before I proceed, sir. On the last adjourned date, this issue also came up as to the 25 billion naira. So between that time and this time, they had the opportunity to amend, to file any application. They did not. That's on one hand, sir.
Yeah.
Now, with respect to the reason they have given, I want to address the substantive reason they are giving for wanting this adjournment. They want to amend their notice of appeal to bring in issues, facts, negotiations, discussions, correspondences that took place during reconciliation They want to bring in concessions and admissions made during negotiation. That is the sole reason they are seeking this adjournment to amend.
Was the negotiation not without prejudice?
My lord, sir.
The negotiation was not done without prejudice.
Yes, sir. But that is it covers that 25 billion naira, for which reason they are seeking the adjournment also.
Well,
Now, I want to quickly refer, my lord, to the same. Okay, sir. I want to refer this honorable tribunal to the same order 1, rule 5 that council relied on.
Which
the objectives of these rules.
Which paragraph?
Order 1, rule 5, particular reference to paragraph B.
Rule 5, paragraph what?
Paragraph B. Order 1, rule 5, paragraph B.
Yes.
Even A and B, I will take both of them, A and B. Now,
Yes.
the objective of the rules are to enable the tribunal deal justly and fairly. And fairly, granting an adjournment to a party to amend a notice of appeal to rely on documents or facts during negotiation cannot be a procedure that meets the objectives of the rules. And that also applies to paragraph B.
Yes.
The rules are meant to encourage and promote settlement of disputes among parties. If the tribunal is minded to grant an adjournment to the appellant to amend his notice of appeal, if the tribunal is minded to grant an adjournment to the appellant to amend his notice of appeal, respectfully we submit, with all due respect, that that is not a procedure that will subsequently encourage parties to approach the settlement table with open hands.
I didn't get you.
If the honorable tribunal is minded to grant an adjournment to the appellant to amend his notice of appeal to bring in documents or pieces of evidence that came up during reconciliation, without prejudice to the appellant's right to amend, we do not think it is a procedure that would encourage parties to appear before this honorable, that encourage parties to appear at the negotiation table with open hands, knowing full well that whatever they say or do at that point will be used against them during trial. So for these reasons, we urge this honorable tribunal to refuse the application for adjournment. Today is for hearing. Counsel should proceed with hearing. His witnesses before this tribunal, they should adopt their second statement on note, tender the necessary documents, cannot be seeking adjournment in between hearing. I urge my lord to discountenance the application for adjournment, sir.
With respect to the tribunal,
Mr. Ajibada,
SARS.
Mr. Ajibada, this tribunal, we started this case on the 13th of March last year. 13th of March 2025. And in between, but the point I want to make is, parties can amend even before judgment. Is it not?
Of course, they can amend. I also have the right to oppose the application for amendment.
Yes. They can amend even before judgment. And that other one, paragraph 5, that both of you cited, whatever the tribunal decides to do is to further the cause of justice. We give both parties a fair chance to be heard. We put all our cards on the table. If the party says, I want to amend, we can't insist on we can't insist that you must go on. At the end of the day, it could be a point for appeal. What do you think so?
As the honorable.
Yes,
are you saying no? Don't amend it. Must go on.
My lord, if they want to amend, no problem. Let them take a date. I'll concede to a date. Let them file their motion. We'll oppose the motion. At that point, one word.
Simple.
That's what I'm saying.
That's the proper thing to do.
As the tribunal pleases.
We can't stop them from.
We can't say don't amend. You must go on. It could be a ground of appeal. And it will not, at the end of the day, do justice to the respondent.
As the tribunal pleases.
When your negotiation, did you negotiate without prejudice? So,
and then on the issue of cost, you didn't even ask for cost. Ask for cost would have looked at it. So since you didn't ask for cost.
My lord, I don't want to ask for cost.
Well, I know you are sitting in your office, so you didn't any expense.
No, I love and I appreciate the smile of Leonard Counsel to the appellants.
My friend, we appreciate the fact that you didn't ask for cost. Luckily, you are attending from your, that's quite magnanimous, but you are attending from the comfort of your offices. And also remember that it took quite a bit of time after we filed our process before the respondent also filed. And we also appreciate the fact that the motion to amend itself hasn't come. When it comes, as you have told us, we see how it goes then, and we will be much obliged again, because we believe that we all owe we owe ourselves that duty, that the tribunal is determining what is life and not what has been superseded.
So, the tribunal will adjourn this case for continuation of hearing, because we have not seen the motion. You can adjourn it for motion.
When the motion is discussed properly, they will take it.
Well, it's not on the tribunal. Yes, and we're praying the tribunal for adjournment to hear continuation of hearing. In between, we would have filed a notice of appeal.
Exactly, that's what I'm saying. Because we cannot adjourn for what we have not seen.
We're much obliged. We're much obliged.
So on the next date, if there's no application before us, your witness should be available.
As the tribunal places.
Yes.
While we've already considered to the adjournment, in line with which also supports my point, as at now, there's actually nothing before this honorable tribunal as to why the matter will not proceed or continue for hearing as of today. But nonetheless, we concede to the adjournment. I wouldn't like to draw this honorable.
We will adjourn the hearing. If on the If on the next day we see an application before us, we will take it. If there is no application, we will continue the hearing.
You are subject to
As
overriding wisdom
the
of the
tribunal
tribunal.
pleases.
So what dates? 11th, 12th, 18th of August.
18th is convenient from our side.
11th, 12th, 13th, 14th,
Not 18. Not 18.
1, 3.
18
Not
on Saturday.
1, 3, 1, 3.
13th.
Okay, 13th.
11, 12, 13, 14.
Those dates are okay.
So,
14 is pretty.
Madam Uloma, hello, Madam Uloma, please, how about your diary? Please, are you looking at your diary?
Yes, sir.
What
The dates are okay.
Yeah, okay. Thank you.
No.
We give it for you.
We give you 11th.
11, Tuesday.
11th,
Can practice confirm if the level is something.
11th August.
Tuesday.
Yeah, very fun. It's a get better.
11th of August is okay, sir. We are grateful.
Sakulabi, 11th.
Okay, very much so, sir. Thank you.
11th of August.
No, 11th of August for continuation of hearing.
Consent of both parties, this case is adjourned to 11th August 2026 for motion or consideration of hearing.
As the tribunal pleases, we are very grateful for the indulgence and also most
Much
appreciation
obliged.
to the appellant counsel.
Thank you very much to the tribunal and to my learned friend.
We're grateful, sir.
Eh?
I always enjoy seeing
We put on
your
our sparring gloves on the next adjourn date.
Are they available?
The only question I'm not saying is fast.
But Nuruddin.
With my respect, sir. Good morning, sir.
Yes, please, we'll take 15 minutes and come back.
Okay, although I don't know whether there is any counsel from the other side.
We've not seen any. We are seeing only you there.
Okay, so that's because if there is no counsel on the other side, that means our matter might most likely not be going on. So that's the case is adjourned for continuation of hearing so that we can make the application that we have. So that
let's take it. Let's take it.
Okay.
all right, sir. Thank you, sir.
Next on the conflict with our case number T80/SSS/032/2023. Celebrating Nigeria Petroleum Limited versus Akwa Ibom State Internal Revenue Service.
You just have your.
Yes. Let me. When I start getting into stuff, in the text. Yeah, in the text. Getting into.
Appearances,
Right, with profound respect to the Honorable Tribunal and the Honorable Chairman, my name is Nuruddin Aziz. I humbly announce my appearance for the appellant. And appearing with me are my learned friends, Dare Shokoya. I also have
Dare.
Cynthia Dare Shokoya. I don't think Dare has appeared before you physically before. I'm not sure, but we have Cynthia Ukezie, which I know that Honorable Chairman is familiar with. Then I have Awal Abdul Aziz.
Our,
Awal Abdul Aziz.
yes,
There is no representative from the appellant.
any party rep from your side?
No party rep. However, I want to use the opportunity to inform the tribunal that our managing partner, which is in person of Mr. Aziz, and our deputy managing partner in person of Mr. Demola Olariwaju are both also monitoring or joining virtually to monitor the proceedings. So I just say, let me.
Are they representing the? Are they
Thank you, sir.
representing?
No, sir.
Yeah.
So there is no so the matter is adjourned to today for further hearing, for continuation of hearing.
Yes.
It is glaring, Honorable Chairman, that the last adjourned dates, over 3 adjournments, the respondent had not appeared before the tribunal, including last adjourned date. Despite the service of the hearing notice on them also.
Yes.
It therefore leaves us without any iota of doubt. It therefore leaves us without any iota of doubt that the respondent are no longer interested in pursuing this appeal. It therefore leaves us no iota of doubt that the respondent is no longer interested in pursuing the appeal.
To pursue or to defend?
Come again, sir.
Is no longer willing to defend or to pursue?
Yes, to defend the appeal, as the tribunal places, to defend the appeal.
Yeah.
The Honorable Chairman will also recall that on the last adjourned day that this matter came up last, the tribunal gave them an opportunity to also come today and ask that a hearing notice be served on them, which I am sure the Honorable Tribunal did.
There was a ruling on the last date.
Yes, the ruling was delivered, then we were supposed to proceed immediately, but they were not in court, so the tribunal magnanimously adjourned till today's date.
The last time we appeared was 17th of February. That was mutual.
Was it 17th or 18th? I think.
That was 17th of April.
All right, sir.
But that's when the argument about expunging evidence of
Yes, that was the last time they appeared in this matter.
May, 17th of April. In May, they wrote a letter of adjournment, wrote a letter for them. In June, there was no letter, they were not available to deliver the claim. Aziz,
Yes, sir.
you know, this tribunal always we give a parties opportunity to acquire that they will not have any excuse.
Okay.
We're not having any excuse. It's supposed to be for defense.
Very well, sir. And that's why we want to make an application, sir.
I think we'll give them a date. On the day they are not here, then you can make your extra.
With respect, sir, we want to make the application so that it will be on record. We don't mind if the tribunal still is obliged to give them another date, but we intend to make this application because ordinarily we would have been there physically, but we discovered that the last 3 adjournments we've been coming physically, expending our resources, money, and time.
If you make that application today, we'll have to rule on it.
There's no point.
So because we are told we're inclined to give them one last chance. On the next date, you can make whatever application you have. If they are not here, they will know how to rule.
Okay, we take the hint of the tribunal and
Give them so that for what purposes you are the appellant.
Very well, sir. So
come with whatever excuses challenging whatever we do here.
I agree with the chairman because we ordinarily were thinking we'll make an application for foreclosure so that before the next adjourned date, we would have filed our written address, but we succumbed to the.
Don't be too much in my place, they say when you remove you want to harvest a mushroom, and you are in a hurry to harvest it. It damages it. So let's give them this plan, give them a date. 11. So just take a date in July. I mean August.
Okay, sir.
11th August.
11th is convenient, sir. 11th is convenient.
But definitely depends.
All right. Although we have a matter tomorrow, though. Of course, I'm not trying to preempt the matter coming up tomorrow, which we already made an application for foreclosure. Of course, the tribunal give them one more last chance, but
so that one, bring on it. The circumstances will differ. It depends on what we see tomorrow.
Very well, sir. Very well, sir. We are most obliged, sir. The 11th is very much convenient.
The respondent was served with hearing notice about today's hearing, but has not communicated with the tribunal. This case is therefore further adjourned for definite defense by the respondent to the 11th of August 2026. Hearing notice is again ordered to be served on the respondent.
As the tribunal pleases, we are most grateful, sir.
Point of prayer.
Tribunal shall not rise, please.
So I need to. I think it's fine. I don't really have any.
No. Nice one. From the heart of please welcome green transparencies. From president.